Dear Andre, thank you very much for your friendly words. I'm happy to be here in Ljubljana again after, I think, 8 years. It was in September 2007 when I had a discussion with the then director, Andrei Plahutnik, and it was very interesting. I learned a lot here in Ljubljana concerning competition and how to behave and how to move in this area of competition and this area of antitrust, and how to discuss, how to behave, how to get in touch with the companies. And I learned that one main focus is we all should not forget is that we do it, for instance, for the consumer, for all of us, if we are competition enforcers. The one, I think this is very important also to mention it and not to forget it. That we also have to look at for the sake of the consumer. Each of us has a concern in antitrust cases on the one hand. I've learned a second thing today, and it also deals with competition. I've learned that Andrei and the Slovenian Competition Authority deals with the skiing area and the ski sector. And the ski sector is also characterized with competition. If I look at the fights between Tina Maze on the one hand and Anna Fenninger on the other hand. And so I was very surprised that the investigations of Andrei here in the skiing sector with the ticket prices, they are similar somehow that you've got so far. I'm suggesting, and I'm here in Slovenia and Ljubljana, so I can mention it, I'm suggesting at the moment to start some sector inquiry in Austria with the ticket prices. They are similar all over Austria. Probably you know it, the ticket for one day. The ticket companies, the companies published it last week, is all over Austria for one area, 51 euro. Probably it's collusion, probably they discussed it somewhere in a circle. And we have to break it up, to break this circle up. So probably it could be an idea to make some joint investigation between Slovenia and Austria. We should deepen it afterwards during lunch or probably during another meeting either here in Ljubljana or in Vienna. I think this could be useful. It's also for the sake of the consumers. Okay. My idea for today is to mention 3 short points that there is also enough space, time for discussions. I will make a short presentation concerning the structure of the Austrian competition law enforcement system. Second point, I will short mention what we are doing in Austria, how we are doing in it, what are our activities, and third point is we'll discuss and present the ideas how we manage the settlement area in Austria. Structure of the Austrian system is we have a separation between investigative and decisional powers. This is a system which exists since the founding of the competition authorities in 2002. On the one hand, we have the Federal Competition Authority, which I'm leading, and the Federal Cartel Attorney. It's a colleague which works in the Ministry of Justice. Difference is the Federal Competition Authority is independent. The Federal Cartel Attorney can be ordered by the Minister of Justice and the formulation or the task is to look at public interest in cartel cases. We are the investigative bodies And on the other hand, there are the decision-making bodies, it's the cartel court and the Supreme Cartel Court. I think it's not really necessary to mention that the separation of investigation and decision-making fully respects the European Convention of Human Rights, of course. I've listed here once again in a chart the dual system with the Federal Competition Authority and the Federal Cartel Attorney on the one hand, and the decision and appeal-making bodies at the court. Let me mention some elements of the dual system. Inspections can only be conducted on the order of the cartel court. A single judge at the cartel court orders the inspection, and so we as investigative body have to file an application to the court, and then we get the allowance to make the inspections or not. In 99% of the cases we get the allowance to make an inspection. We have the exclusive right to file applications to the cartel court, and cartel court renders its decisions only upon application. There is no ex officio system. The BVP, my authority, and the cartel prosecutor or cartel attorney, we are parties in the court proceedings, and we may appeal, of course, against cartel court decisions to the Supreme Court. We will later see that the Supreme Cartel Court has only to answer legal questions. Our application has binding force for the cartel court concerning the maximum amount of the fine. Cartel court can't go higher, but he can't refuse to accept our application and can send it back, of course. How does it work in practice, this formal separation between investigation and decision-making powers? I've listed some cases here. It was the elevator and escalator cartel. We proposed a fine totaling 88 million euros to the cartel court, and cartel court imposed a fine about 75.4 million euros. We had an industrial chemical wholesale cartel. Proposal was 1.9 million euros. Cartel court imposed this fine. Printing chemical wholesale cartel proposal 1.5 million euros. Cartel court imposed a fine of 1.5 million euros. Additional to that, it's interesting to mention that all settlements we gave to the court were accepted by the court. All the settlements, we come later on to these cases in more detail, and nearly each search warrant were also accepted by the cartel court. We have a lot of procedural guarantees, of course. We have to make a written application to the court. There is the right to reply to our initial court pleadings for the companies, of course. There is access to file during the proceedings before the cartel court, but on the other hand, of course, there is no access to the file during our investigation, of course, and during our proceedings. There is an oral hearing before the court, and if there are further proceedings, it depends on decisions of the cartel court, of course. Cartel court consists of 4 members. There are 2 judges. From the Ministry of Justice on the one hand, and there are 2 judges nominated by the Chamber of Commerce and the Chamber of Labor. So it's a mixed system, very interesting. And we have also, of course, all the constitutional procedural guarantees which are met by the court as independent court, of course. There is a cartel court's decision, at least. If we have 4 members, it's the question if the discussion goes 2 by 2, then the presiding judge has the right to decide. It's possible to plead, to make an appeal to the Supreme Court, to the Supreme Cartel Court. Only the court's legal reasoning can be appealed. And on the other hand, the Supreme Cartel Court has full jurisdiction to review the fines imposed by the Cartel Court. In this case, the fines could be higher than the decision of the Cartel Court. Second, Austrian competition authorities, some facts and figures. We are founded in 2002. We're a small competition authority with 26 case handlers with a budget of 2.7 million euros. On the one hand, on the other hand, we conducted from 2011 to 2014 83 inspections. So one inspection per month, I think. Only Russia and Turkey has conducted more inspections in this area. And there were fines given, there were over 150 million euros, and the last year there were 21 million euros in fine on our proposal given by the court. Here is a list of activities. We have around 300 merger notifications a year on the one hand, and about 50 cartel cases and 23 cases of abuse of a market dominant position, and also a lot of European cases, also 300 to handle. So summing up, it's I think 800 cases. Which instruments do we have to do our work, especially in the cartel area? Here we can send the request of information to the companies, we can ask that they submit some documents, we can question them, and we can make inspections. We are free to choose which method we will make in a certain case. And we had a lot of amendments of our regulation. One further amendment is now pending, will be take in force probably next year. And we have I think we are a successful leniency program. Since 2006 we evaluated this leniency program in 2012 together with the business community. If we look at the request of information, we can also direct it to third parties. We can ask, of course, open questions. We can ask statistic informations. The number of questions or the addresses can be very high, of course. We can send it by letter or by email. It's an official form. We have a time limit to answer. Incorrect statements can be fined by the court, of course. It has already happened also in Austria. Questioning. We have the possibility of a formal invitation. They are made notes with date, place, involved persons, topics, process, and subjects. Lawyers are allowed. Suspected persons do not have to give information, of course, and notes have to be signed afterwards. If we look at the inspections, we file an application to the cartel court with a reasonable suspicion on our side. and the search warrant is made by the cartel court, by one judge, the cartel court, and it's executed by the authority. Legal provision says that we are supported and by the police, by the Ministry of Interior, of course. Searching third parties is, of course, also possible. And we have also, because it was mentioned before, we have also the possibility through a decision made by the Supreme Court, the Supreme Cartel Court, that we can use things or papers or evidence or emails we found during inspection, which doesn't fit to the application, and it's also allowed. One point which is more important, as we realize in the last time, it's the IT-based searching. It gets more and more important because the classic cartel that you exchange paper or you sign a paper with your idea of cartelizing does not really take place in this at the moment. At the moment there is some exchange of emails between the cartelists. The one hand are probably they putting their evidence in some cloud somewhere over the world. So I think this is very important to be prepared for a very good IT-based searching concerning smartphones, concerning laptops, external servers, wherever they are. There are a lot of legal problems inside. To mention it open, I think there is no really at least very good solution on a national level, but I think also not on a European level to work hard to get here a good solution on the one hand for the competition authorities, but also on the other hand for the companies. It's one argument. If you say, and we had a situation during one this inspection that the company argued that the server does not stay in Austria. The argument was the server stays in the Czech Republic. So we had to go back to the court to get another application and a search warrant, but it worked, and then we get in contact with the Czech colleagues through the European Competition Network. But it's more and more important, the IT-based searching. Third point, settlement. Situation in the European Union is, it was introduced in 2008. It's possible to get a reduction up to 10%. The average duration of the cases was reduced by 2 years. The fines and settlement cases are 42% of total fines since 2010. If I'm right, I won't discuss it. We'll hear it later. In Austria, became common over the last 3 years. Over 53 million euros were imposed in settlement procedures since 2013, together with the court. Over 20 cases were settled in the past 2 years in Austria, and the average duration was less than 1 year. So, on the one hand, it's a procedure which saves time for the company on the one hand, saves time for the authority, and saves also time for the court, of course. We realized that it was necessary that we publish some guidelines on settlement, how to deal with settlement, how is the procedure, how does it work, which reduction could be given in a certain case, and so on. And we drafted in our authority guidelines we discussed it with the competition family in Austria. It was very interesting. We discussed it also with the court, of course, and then we published it. So they are public, and you can download these guidelines on settlements from our homepage. Main features for settlements are the reduction of fines, the shorter procedures, the decisions are a little bit shorter. There is a settlement statement. There is somehow the right to appeal if everybody agrees with the proposed decision. Nobody will make an appeal, of course. In most member states, the competition authority renders settlement decisions, of course. Cartel court renders the decision, makes a public hearing, and the appeal, of course, is possible. But there is no case, of course, if everybody agrees with a settlement statement. How can we define the settlement? Somehow different, but there are some common points. It involves cooperation of undertakings, concerned with facts, with legal assessment, probably also with the aid of a fine. It leads to shorter proceedings, possible also to shorter decisions, but it depends on the application, of course, and it depends on the decision of the court. And it involves a reduction of fines, 10 up to 20%, depends on the case. I've listed up for you also the pros and cons of settlements. The pros already mentioned: fast procedures, a fast correction of behavior to the benefit of the market, benefit of the consumers, okay, of course. It's efficiency with time and cost factor. It's an incentive on the one hand for companies to cooperate outside leniency. And it reduces the burden on judiciary authority and setting party, of course. Cons: the decisions could be somehow more or less substantial. There is probably an hampering impact on private enforcement, but this is another question. Facts and legal points are not really treated in depth, of course, and it could be that no jurisprudence develops. Our idea was that we make guidelines and we will evaluate and probably make new guidelines to work about it. The defense rights cannot be, so one argument, exercised in the same way, but if everybody agrees, it's an advantage for everybody. And there is also one argument that there is less transparent procedure. We should take in consideration some questions. At which stage of the proceedings you should enter into settlement talks, which information should be available on the one hand, how to deal with different cases with different approach, where one part is ready for settlement and one part is ready for leniency, and which extent of cooperation is required. These are some questions. I've listed here up the chapters of our Austrian settlement guidelines. All kinds of procedures are covered. It's open to all undertakings. We want to have a certain level of information before entering into talks. There is the scope of reduction up to 20%. We are discussing the settlement declaration with facts, legal points, and possible fine. We also discussed the judicial review and the transparency, and once again it's available for download under our homepage address. Probably one judgment, sorry Judge, only one judgment. The Commission is not bound by the fining range indicated as part of the settlement procedure, of course. There are some challenges, of course. It's the so-called hybrid case. It's the confidentiality the rights of defense versus efficiency, the interplay with damage procedures, and I think very important to find a balance between ensuring the effective application of competition laws on the one hand and ensuring fair, free and transparent procedures, of course. If I try to sum up, before I do that, I have to mention a second case, and a second common case detected today when Andres made his introductory remarks. It's the telecom sector. We are at the moment conducting a sector inquiry. Austria will finish our sector inquiry the end of October. This year, we had a merger 2 years ago where it went from 4 to 3. We mentioned that that the prices, especially in the mobile phone sector, will raise up to 30%. And this happened after the merger. There were some remedies given by the Commission that MNVOs could get into the market, and now it happens. Now the prices are falling in the mobile phone sector. So probably this could be a second point for information exchange between our two companies. And Andrea, you and your case handlers are invited to Vienna so that we can discuss these two cases, skiing and telecom, if you like, and I would appreciate this very much. Let me make some final remarks in three short points. From our point of view, I think legal and the final certainty is very, very necessary. I think a fast clearing of competition questions is necessary, and it's everybody has an advantage of it. The authority, courts, the parties, the ministry, everybody. If there is a fast clearing. And we made one further experience, that is that somehow one case, one procedure approach is the best for all the stakeholders. And we are working on it, and I think this is the key issue, to say one case, one procedure is the best for all the stakeholders, for the companies, for the lawyers, of course, for the authorities, for the Commission, for the ministries, and for the court. So thank you for your attention. Interesting, looking forward to a fruitful discussion. Thank you very much.